Monday, Donald Trump will become the first former president to stand trial on criminal charges. He's accused of falsifying business records to hide a hush money payment to a pornography worker named Stormy Daniels. Manhattan District Attorney Alvin Bragg says Trump wanted to hide an alleged affair from voters ahead of the 2016 election. This is one of the 4 criminal cases the former president is facing, and he denies all the charges and calls the indictments a political witch hunt. Some legal analysts say he's absolutely right.
These indictments all have one common denominator, Brian. They're politically driven. And Americans see this for what it is, an abuse of our legal system meant to interfere in the presidential election. But, polls show it's backfiring, only solidifying Trump's support. And voters see him as a victim of unscrupulous political enemies who are weaponizing the law.
A Politico column lays it out this way. Surprising strategy Trump could use on this. Quote, first watch for the defense to take a wrecking ball to Michael Cohen, the former Trump lawyer fixer and key witness, in the hopes of taking the whole case down with him. Then there's another, less explored route, asking the judge to give the jury the option of convicting him on lesser misdemeanor offenses instead of felony counts. Phil Holloway, former assistant district attorney and former police officer. So that last one is really interesting. You don't hear that out there very much. Could that happen? Could you go from felonies to misdemeanors? And what would that mean for Trump?
Yeah, you can always ask for a lesser included charge. But Harris, speaking of misdemeanors, this case really started out as a minor bookkeeping misdemeanor that the statute of limitations should have run on years ago. But it's Alvin Bragg who is the one that, in my opinion, is being dishonest, because he's taking this misdemeanor and he's bootstrapping, federal election law and trying to call this some type of serious felony fraud, which really is just a bookkeeping issue. And by the way, speaking of fraud, it's another example of a New York prosecution going after Trump where there's no victims. Nobody was harmed by any of this. And by the way, can we stop referring to it as a hush money trial? That implies that there's something sinister, there's something illegal about non-disclosure agreements. They are standard. Wealthy people, prominent people use them all the time. Even Fonnie Willis here in the Fulton DA's office has non-disclosure agreements with people in her office, I'm told. So I wish we would not refer to it as a hush money trial, because that implies that there's something sinister. The bottom line is nobody was hurt. At most, this was a bookkeeping issue. This was something that the statute of limitations, if it was a crime, was expired years ago. And that would even be assuming there was some kind of fraudulent intent by Donald Trump. The bigger question is, can he get a fair trial in New York?
Well, that.
And welcome back Inside the Law, folks. I'm your host, Philip Holloway. And of course, here we're taking you inside the law in the context tonight of the groundbreaking criminal trial of former President Donald Trump that's currently underway in terms of jury selection in Manhattan as we speak. So the question that you heard me pose to Harris Faulkner in that video clip was, can he get a fair trial in Manhattan or in New York City? So we're going to be looking at this issue of what is a fair trial, what does a fair jury look like, and what is a fair and unbiased judge, and all the things that you have a right to, including a right to know exactly what you're being accused of that's illegal. So all of this stuff that we're talking about, and you hear people talking about in the news relating to this trial so far, pretty much all has to do with the Sixth Amendment to the United States Constitution. So with that, I'd like to go ahead and introduce you to the Sixth Amendment, and then we're going to talk about it. Okay, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That's the Sixth Amendment. And there's a lot of stuff in there, but since we're talking about fundamental fairness and we're talking about a fair trial and an impartial jury and being put on notice of what you're accused of, I figured we may as well start with the Sixth Amendment. One of the things in there that I want to start with is basically the right that criminal defendants have to know exactly what they have to defend. Now, those of you who have taken a look at the notes for this show, the video description, you've noticed that I put in there that there's a problem with the indictment that Alvin Bragg has brought. So I want to go ahead and let's go ahead and just dive right into this indictment, because I want to explain to you what I mean. And I'm going to make this full screen. Get me out of here for just a minute so that you can fully see it, hopefully. All right, so this is the indictment. And I'm not going to go through all of it word for word, but you can see here we're dealing with penal law 175.10. And it says the defendant in New York and elsewhere on or about February 14th, 2017. That's an important date. We're going to come back to it. It says that he, with intent to defraud, and it's worth pointing out here that there's no victim here. When you think about fraud, somebody's got to be defrauded. Well, there's no victim here that's been alleged. So once again, we've got a fraud case in New York involving the former president where there is no victim. Nevertheless, Alvin Bragg says there's the intent to defraud and intent to commit another crime. Okay, you see this where it says intent to commit another crime and to aid and conceal in the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen dated February 14th, marked as a record of the Donald J. Trump Revocable Trust and kept and maintained by the Trump Organization. Count 2, it still cites to this same code section, Penal Law 175.10. And again, it says, and there's 36 or so of these. I'm not going to go through all of them because the point can be made here just by going through a couple, because they're all the same. It says, with intent to defraud and intent to commit another crime and aid in the conceal and commission thereof, made and caused a false entry in the business records of the general ledger for Donald J. Trump Revocable Trust. Okay, so these are all very similar charges. And so the reason that I wanted to pull this up and to share it with you is because the defendant, Donald Trump, cannot possibly be on notice for what he's accused of. So let me go ahead and show you what the felony version of this law is. Okay, the felony version, which is cited in that indictment, 175.10, says a person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, which is the misdemeanor, and when his intent to defraud includes an intent to commit another crime or to aid or conceal in the commission thereof. Well, since it says you've got to commit the crime of falsifying business records in the second degree first, let's take a look at that. This is the misdemeanor version. This is section 175.05. It says a person is guilty of falsifying business records in the second degree when he makes a false entry in the business records of an enterprise, or alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, or omits to make a true entry in the business records of an enterprise, or prevents the making of a true entry in the records. It says falsifying records in the second degree is a Class A misdemeanor. All right. So what am I getting at here? What I'm getting at is there is a misdemeanor variety of this statute, which, if you believe the facts to be true, if you believe that Donald Trump or someone acting on his behalf made a false entry into the business records of the, let's just call it the Trump companies, right? Because they're very complicated, but for purposes of this, we'll just say the Trump companies. If there's a false record that was made and there was an intent to defraud, and that's a big if, then that was a misdemeanor, and it occurred in February of 2017. The statute of limitations is 2 years. They extended it by about a year because of the COVID backlog. A lot of states did that. They tinkered around with the statutes of limitation. And so at best, we've got 3 years, which by my math means that the statute of limitations ran in around 2020. And here we are in 2024. So the only way that Bragg can make this thing still viable is to somehow make this a felony. So he's got to travel under the felony version of the statute. And I'll show it to you one more time. All right. It says that it's the same thing as the misdemeanor, but it says when you commit that misdemeanor in order to commit another crime. Well, back to this indictment. It says another crime, but it doesn't say what the crime is. It just says another crime. And if we go back to the Sixth Amendment, it tells you that, you've got an absolute right under the Sixth Amendment to know what you're being accused of so that you can properly defend against it. The question that I've got, and I don't really have an answer, but the question is, how does this indictment hold water? How does it stick? How has the judge not dismissed it? Now, it's very possible that Donald Trump's lawyers have we don't have a lot of access to all the court records on this, but it could be a matter of trial strategy. Maybe they're going to argue to the jury the same things that I'm pointing out to you here. Or maybe it's just the kind of thing they're going to have to wait until the appeal in the event of a conviction to raise these issues on appeal. But we've talked about on this show and elsewhere, we've talked about what's called an interlocutory appeal. So I don't know why this is not being appealed on an interlocutory pretrial basis, because it's very important. If you don't have an indictment that tells you what the hell you did wrong, it just says that you did this business record bookkeeping thing with the intent to commit some other crime, but it doesn't tell you what that other crime is, then you are not on legal notice of what you have done wrong, what you have to defend against. For the lawyers out here, and perhaps in this chat, somebody needs to try to explain to me how you can defend a client against charges that are so vague and non-specific as this. I mean, what other crime are they saying he was trying to cover up? And by the way, I'm not the only person who has raised this. I'm sure you've listened to other people and you've heard other people, talking head types like me, raise some of these same points. But I'd like to just draw your attention real quick to my friend Andrew McCarthy wrote for National Review. Okay. And Andrew writes that if Bragg's true purpose were to prove the New York crime of falsifying business records, his case would be simple and transparent. Trump directed Michael Cohen in 2016 to pay porn star Stephanie Clifford, also known as Stormy Daniels, $130,000 for signing a non-disclosure agreement, which, by the way, non-disclosure agreements are legal. They are contracts. They are mechanisms used commonly by people who are wealthy, people who are in the spotlight, people who are high profile. They're used to cause people to keep their mouth shut about things that, for whatever reason, they don't want public. It could be a business secret, a company secret, a trade secret, things like that, or it could be some kind of salacious news, like what this is alleged to be. Whether it's true or not, people sometimes pay essentially a ransom to keep people from making claims or allegations about them. So this is not at all something that's unusual or otherwise illegal. In any event, so the $130,000 was for signing this non-disclosure agreement. In exchange for money, Clifford would remain silent about an affair she claims to have had with Trump in around 2006. Are we really talking about something in 2006? Anyway, this is a claim that Trump denies. Yet when it says, yet when Trump paid Cohen when he paid him back in 2017, the payments were recorded in Trump's books as if they were compensation for ongoing legal services. And that would be it. And that, by the way, if those are the facts of the case, that is the description of the misdemeanor. Okay. That is a description of the misdemeanor crime. The title of this, by the way, and you should all go check it out. This is Bragg falsifies business records charges against Trump. And Andrew is exactly right. Bragg has, in fact, falsified this because he is essentially trying to say that there was a federal election law, okay, that was somehow violated. Okay, Michael Cohen pleaded guilty essentially to making an illegal campaign contribution through this whole thing. That doesn't mean that anything Donald Trump did was illegal just because Michael Cohen himself has taken a plea deal. And so here we are as we're trying to pick this jury, and what we have is a situation where Donald Trump has no idea what it is he's supposed to be defending against. Let's go back to this indictment and let's see if I can add it back here. So the indictment says, again, we're in count 2. It cites the felony version of the statute, and it says that he committed the misdemeanor, but it says he did so with intent to commit another crime. Again, an unspecified other crime. Third count, same thing, falsifying business records in the first degree. Felony 175.10. And it goes through this all the way through. And in every single count, it just says he did this with intent to commit another unspecified crime. Unspecified crime. It's just unbelievable, because we've got the Sixth Amendment. Let me come back and share that with you guys once again. The Sixth Amendment, in case you forgot, it says, in pertinent part, it says, the accused has the right to be informed of the nature and cause of the accusation. The right to be informed of the nature and cause of the accusation. Here, the accusation, of course, is unspecified. It simply says he did this misdemeanor that he can't be prosecuted for because it's now way too old, but we're going to make it a felony, and we're going to say that he did that misdemeanor to commit some other crime, but we're not going to tell him what crime it is. So I don't, for the life of me, have any idea how anyone is supposed to defend against this. Let me take a break just a minute to check in here with the chat. We've got 1,286 people in here right this minute, and I want to say that's fantastic. Thank you all for being here. Thank you all for participating in the chat and for watching. And if you don't mind, while you're here, 1,294 of you, go ahead and hit the like button, because that's really going to help a lot, because that's one of the easiest and cheapest way you can support this channel. We really appreciate it. Thank you so much. And if you like the content here, feel free to check out the links in the show description to provide any support. I wanted to start out talking with you about this indictment. And as I've said, in my opinion, there's no way this indictment passes legal muster, because it does not put anybody on the defense team on any kind of sufficient notice to properly defend against this case. In other words, let's just say you can admit for the sake of discussion that Donald Trump personally did the books for the company when he was president of the United States, and he personally wrote this information in the books and in the ledgers of the business. Okay, assume that that's true. You could admit all of that stuff, and you still can't defend this case, because you don't know what the other crime the DA says you committed was. You just don't know, because he doesn't specify. Now, he can go out in the media and he can say on television what he thinks the other crimes might be, and he can file other things, but he's got to put it in the indictment. The indictment is the charging document. That is what puts the defendant on notice. It's not a press release. It's not a news conference. It's not something he says to his friends at a cocktail party. He's got to put it in the damn indictment, or it's an insufficient indictment. And that's really all there is to it. And so this is not about Donald Trump. This is not about whether or not you like Donald Trump or you hate Donald Trump. If you like fairness in the criminal justice system, and you think defendants ought to be treated fairly, and if you think the Sixth Amendment and the Constitution matter, then you should be afraid of prosecutors who prosecute people in this way, because it's dangerous. It's dangerous to our republic, and our system will collapse if something isn't done about it. A couple of nights ago, my friend Julie Hamill was here, and we were talking about in another context of the First Amendment, can we count on judges to do the right thing? And the answer that unfortunately she and I came up to is no, we can't. And so I don't know why this judge hasn't done the right thing, but it is so plain and so simple to understand that this indictment is defective. It's deficient. It needs to be thrown out. Maybe send the man back to the grand jury if he can get another indictment that clearly specifies. Maybe that's the answer, but it hadn't been done. So the question is, why hasn't this judge tossed this indictment out? And do we really have to wait until there's a potential conviction and an appeal years later to have an appeals court decide what I've just explained to you here right now, that this indictment is defective? It doesn't put him on notice. It's not valid. It's just not valid. All right. So now that I'm up on my soapbox, let's see what's going on in the chat room. Again, there's always a lot of folks. I want to say welcome, by the way, to the new members of this channel. Senior Chief, thank you for gifting 5. Welcome, Carolyn. Megan has our chat boss, Megan, who's doing a great job keeping order and enforcing law and order in the chat room. She's gifted 5 memberships. Thank you very much. Let's see. Robin points out that Michael Cohen's a convicted perjurer. And Robin's correct. Michael is a convicted perjurer. And so let's talk about that for a minute. The reason that is important and the way that it can be used is in a criminal trial. The minute a witness puts their ass in the witness stand, their credibility becomes an issue in the case, just as much as any other issue. The credibility of a witness is always an issue. And so convicted felons under our law are deemed to be not credible. And so the jury should be told that when a witness is a convicted felon, that witness, you can choose on that basis alone to fully and completely disregard all of their testimony. In addition to the prior felony conviction, we call that impeachment, by the way. It has nothing to do with the political process of impeachment, but the legal process of impeaching a witness is such that you basically expose their bias. And another way to do that with Michael Cohen is going to be to expose his prior inconsistent statements. He said one thing on one day, he said another thing on another day. I've heard various video montages. I wish I had them to play here, but he's talking out of every side of his mouth, and he's obviously not capable of figuring out what the truth is and sticking with that. So that's going to be something that's going to be an issue to watch in the case. But before I get to that, everything that I just said assumes that we've got a fair jury. It assumes that we've got an impartial jury. We've got a jury questionnaire in this case that asks a lot of things, but one thing that it doesn't ask, and one thing that the judge is not allowing these lawyers to ask, is who did you vote for? Who did you vote for? So we've got a situation where the former president of the United States and the presumptive Republican nominee for president this year is on trial, and he was a candidate in 2020 as well as the incumbent, and yet, and this is about conduct, by the way, that has supposedly occurred when he was in office, and you can't ask the people on the jury, who the hell did they vote for? I mean, you can't ask them, did they vote for Hillary in 2016? Or did they vote, or was it were they an anti-Trump vote? Are they a never Trumper? You can't ask these things. Every single trial I've ever participated in, every criminal trial involves an elected prosecutor, an elected judge. And guess what we always ask? And nobody ever questions it. We asked the jurors, have you ever given money to the prosecutor, the elected district attorney? Did you vote for the elected? Did you campaign for the elected district attorney? And the same thing for the judge. Are you a political supporter of this judge, or are you a political supporter of the prosecutor? Is a very relevant question, and it's one that is one of the best ways I know of to flesh out whether a jury or a potential juror has some kind of bias that I need to know about to protect my client's Sixth Amendment right to a fair trial. I want to share something with you. Speaking of what's going on with the judge and the potential jurors, let me see if I can pull up the right. Here we go. All right. So this is from my Twitter feed. I reposted these so I would have them here so I could easily pull them up and show you. So earlier today, this says, Judge Merchan rules that the juror who joined a Biden election victory parade is not disqualified off the jury. You heard that. So a potential juror who joined a Biden election victory parade is not disqualified. The reason? Because the juror claimed she thought it was a celebration of essential workers. And then here's one. Megyn Kelly has, my friend Megyn Kelly has retweeted this. And you have Brian Krasenstein, and he says, breaking, Judge Merchan seems to imply that President Trump may have tried to intimidate a juror in the courtroom just now. The quote, Mr. Blanche, while the juror was at the podium about 12 feet from your client was audibly muttering something. I don't know exactly what he was uttering. It was audible, and he was just gesturing, and it was in the direction of the juror. I won't tolerate that. I won't have any jurors intimidated in this courtroom. I want to make that crystal clear. Take a minute to speak to your client. To which Megyn Kelly correctly pointed out, juror intimidation with a question mark because he muttered something unintelligible. This is ridiculous. And Megyn is exactly right. It is ridiculous. It is absolutely ridiculous. And this is what's passing for in America today, the selection of a fair jury. This is what's passing for due process. This is what's passing as fundamental fairness. This is what's passing as satisfying the Sixth Amendment to the Constitution of the United States. Speaking of jury selection, there's another thing that is an issue that I've been thinking about, and that is the issue of stealth jurors. Now, what is a stealth juror? There are people who will lie in order to get onto a jury for some nefarious reason, no doubt. Maybe it's because they want to sway the result, or maybe they just know it's a high-profile case and they want to be on TV, or they want to write a book deal. These people will answer the questions as if they have no bias. Oh, yes, of course, I can be fair. No bias, none at all. I'm your perfect juror. And then they get on the jury, and then they do what they claim to do, which is to either convict a defendant, well, regardless of the evidence, or sometimes it's the other way around. Sometimes it's meant to sabotage the prosecution's case and to acquit somebody. Those are called stealth jurors. And one of the best ways to combat against a stealth juror and to flesh these people out is by asking good questions, probing questions, questions that are designed to expose their bias, but that don't just rely on their word, because they're under oath when they answer these questions, but people lie under oath all the time. Just look at Fulton County, but that's another story. What you got to do is you've got to do some background research on these people. You've got to look at their social media posts. And I saw another, and I didn't save this tweet. I apologize. It just popped into my brain, but I saw one earlier today where their social media post was at issue in the case. And it was going back to, I want to say, the early days of the maybe the first Trump campaign, and it was really, really, like anti-Trump. And the judge said, well, I wouldn't have had a problem with it if except it went a little bit further. And so they're looking at these people's social media posts and they're saying things that are anti-Trump, but the judge is giving them a lot of leeway. In other words, if you find a social media post for one of these jurors, it's got to be really, really, really far out there before the judge will do what's called an excuse or a strike for cause. And by the way, we're not at the point yet of these parties having to use what's called the peremptory strikes, which they can use for almost any purpose. They can use, you can't use a peremptory strike, for example, to strike someone because of their race, their gender, certain things like that. But you can do a strike for cause, which means because the person is so biased that they can't be fair, they can't comport with the Sixth Amendment. You can use as many of those as you need, essentially, but the judge has to agree. You can't just say, I strike this person for cause because they can't be fair. The judge has to agree with you that they can't be fair. So again, the judge here, the same judge who's, admonishing Donald Trump for intimidating a witness, even though he admittedly has no idea what Donald Trump said. This is the judge that has to agree with these things. So you get an unlimited number of these strikes for cause. They've gone through, it's my understanding, another 100 or so today, and they've got 6 jurors out of almost 200 or so that are what we call qualified, which means they now make it to round 2. Think of it like, American Idol. They're moving on to the next phase, which is going to be the final jury selection, where the parties will get to use additional strikes for cause and their peremptory strikes. So anyway, that's what's going on, and this is something that really I hope everybody is watching this trial, because the question of whether or not somebody can get a fair trial is so important. That's what the Sixth Amendment is all about, but it's also what the Fifth Amendment is about. The Fifth Amendment due process means you've got a right to a fair and unbiased judge. That's part of that, right? So if the judge is not unbiased, then what's going to happen is you're going to be left with a biased jury. And of course, you've got a biased prosecutor. And now you've got the system that's coming off the tracks. I mean, the wheels are now completely off this thing before it's even out of the gate. And so we've got to ask ourselves 100 years from now, or 5 years from now, 10 years, whatever, will we look back on this process? And will we or future historians decide that they like what they see? Will they say we have some confidence now in the result of this thing? If the answer is no, then, we've got a problem. Because, again, this is not about Donald Trump. This is about the process being fair. This is about the process yielding a result that we can rely on and that we have faith in as being just, because that's what justice is. It's based on the word just. So is this a righteous prosecution in the first place? If it is the trial conducted in a righteous manner? If it is, did the jury behave itself? If it does, then maybe you got a just result. But if the answer to any of those questions is no, then the result is by definition unjust. So, and by the way, if this were Barack Obama on trial, or if this were Bill Clinton on trial, or if this were Joe Biden on trial, I would say the same thing, because it doesn't matter whether you like the defendant or you don't like the defendant. What you got to understand is the system must be fair, and it must be impartial, and it must be conducted. These things must be conducted in a way that history will look back on it and say, we have confidence in the result. If there's a conviction, it was the right thing. All right, let's check back in here into the chat. I got a lot of folks here I need to thank. And by the way, I'm waiting on a very special guest to check in. I'm going to be joined here shortly with by Ashleigh Merchant, who those of you probably have never heard of her. She's Nobody knows who she is, but of course, she's the person who is the Aaron Brockovich of the Fani Willis saga and fiasco that's unfolding in the Fulton Superior Court, and there's currently an appeal on her disqualification. Ashleigh is supposed to be joining me. I'm looking for her anytime, so if you see me looking down, I'm checking to see if she's about ready to join us. She has something she had to do with her family, and as soon as that's over, she promises she's going to be in. But in any event, I want to say again, thank you to all the folks who are in the chat room participating. We have just over 1,500 people in here right now. And what I'm going to do is I want to acknowledge the people that are posting the super chats and the gifting the memberships. So generous. Thank you. Thank you, Ray. Ray says you have the blue lights. Here's $5. Well, they can change color. I don't know how to do it, but maybe before we wrap up here tonight, my son can hand me the remote control and teach me how to do it. But yeah, I'm making some changes, and hopefully things will just continue to improve. And your support is what causes that. Thank you, Ray. Bruce, thanks so much. Purple AJ, the judge will not allow any facts that support Trump to come out. And, that's kind of the one of the points that I want to underscore is that judges, they must always be mindful that history is going to be judging what they do here, and so they can't even have the appearance of impropriety. So if half of America believes that this is a political prosecution or it's not being conducted fairly, is that, doesn't that just tear the country apart further? Is that what the justice system is supposed to be all about? What these people, what Alvin Bragg and Letitia James and Fani Willis and Judge Merchan, all of these people that appear to be going after somebody because they don't like his politics, those, in my opinion, are the real villains. Those are the ones that tear down the justice system, and those are the ones that cause this to be a process that we can't have any faith in. You can't just go and say that somebody made a bookkeeping error that was a misdemeanor, that the statute of limitations ran years and years ago on, and somehow convert that into a felony just simply by saying that the judge did that for the purpose of the defendant did that for the purpose of committing some other unspecified crime. It's preposterous. It's absolutely preposterous. All right. So we got some interesting comments. Let's just see what's going on in the chat room. So Ashleigh is the one lady who will never wear her dress on backwards. I think that's probably very true. John says it's like a rigged trial of an innocent black man in the Jim Crow South with an all-white jury and a Klansman judge. And John, I think you're right on. I mean, that's obviously different time and different era, but the core of what you're saying is absolutely true. It's a rigged process that is not designed to be fair. The trials of the innocent blacks in the Jim Crow South, those were not designed to be fair, and they rendered results that were unfair and that were unjust, and lots of horrible injustices took place. But are we seeing, in a way, are we seeing history repeat itself? Not on the basis of race, but on the basis of politics. What is your politics? If I don't like your politics, then by God, I'm going to use every ounce of my power as a judge or a prosecutor to come after you, to silence you, to shut you down, and to make sure that you do not ever participate in public life again. Because that's what when you charge somebody with 36 felonies, that's what you're doing. When you're charging somebody with 36 felonies, you're basically saying you are not welcome in public life, and so I am going to put you in prison. That's what this is about. It's erasing people from public life altogether. Carolyn says we seem to be heading towards Marxism, and that may be true, but this is very different than Marxism. This is this is a sinister misuse, in my opinion, of the criminal justice system. And so it's, I think, different than Marxism, but still very, very dangerous. Caustic Chameleon. They either don't know or don't care that they are making a martyr of Trump. They keep making him more powerful with every unconstitutional abuse they subject him to in this kangaroo court. And I think there's some truth there as well, because Donald Trump is, a lot of people, I think, are seeing, that maybe they don't like the man. Maybe they've had enough of what they think, the mean tweets and all, but maybe they just don't like anything about him. They don't like how he talks, how he looks. They're just repelled. They're repelled by him personally. They can still see what's going on, and they can see that this is not right. And because they can see that, a lot of people are opening up to being sympathetic to somebody that maybe they weren't sympathetic to previously. And so this absolutely can come back to haunt them. But what the big concern really needs to be, this trial could take, 5, 6, 7 weeks. What happens at the end of that 7 weeks if a jury finds him guilty? Every trial I've ever been in, when somebody was found guilty, the judge immediately revoked their bond and threw them in jail. May have even sentenced them there the same day, but at least said, okay, you're going to be in jail until we sentence you in 2 or 3 weeks or a month or whenever. And so that's what happens. And then the appeal comes later, right? And the appeal takes years and years and years. I just read a story here in Georgia. Somebody was just won a new trial after being in jail over 25 years for something they didn't do. I mean, you don't want to put your eggs in the appeal basket, particularly in a criminal case when somebody's freedom is at stake. And another thing that I've thought about is, let's just say the judge does try to put the man in jail. And by the way, the district attorney's already asking for Trump to be held in contempt of court for violating the gag order. But let's say that the judge does at some point decide he's going to put him in jail, whether a jury has convicted him or whether the judge thinks he's intimidating a witness, which is the absurdest thing ever. He was not intimidating any witness. But let's say the judge decides he's going to throw him in jail. What happens? Does the Secret Service allow that to happen? Does the Secret Service say, okay, we'll let that happen, but we're going to go with him? He is entitled by law to Secret Service protection for the rest of his life, no matter where he is. That's the law. That's federal law. So I don't know. And so these are questions that I'm just posing and I don't know the answer to. I'd love to hear. Look, and by the way, speaking of this chat, if you agree with anything I say or you disagree or you want to comment, please put it in the chat, because we want to hear from you. I want you to tell me what you think about these things, because I don't have all the answers. I know how to ask questions. I don't know some answers, but I don't pretend to have them all. So I want to hear what some of you folks think how this might play out. Don says house arrest at Mar-a-Lago. That's actually something I've thought of, and you put LOL at the end of your comment, but hey, it could happen because it's just so impractical. Let me see. Okay, Ashleigh just texted me. You'll be glad to know that she's home. She's setting up. She'll be here soon. All right. So while we're waiting on Ashleigh, let's see what else other people are having to say. Marjorie says the Secret Service has to go with him, and I think that's probably the right answer. But all right, so let's say you're the Secret Service agent, right? And you're detailed to stay with and you get sent to Rikers Island. And that, and you've got to stay. Where do you stay in the cell with the man? I think you have to. You have to stay in Rikers Island if you're there with Donald Trump. All right. So we've got, yep. Yes, Good Logic was in court, and I've got his cell number, and I'm going to text him. I'm going to try to get him on this show. We're going to talk about what he's seeing. So yes, you're exactly correct. Kenneth says, if he's convicted of a felony, would he lose his protection? I don't think so. But I don't know that. It's a matter of federal law. I've never heard that that's the case. Barbara says it doesn't matter if you like Trump. God has anointed him. I don't worship Trump, but I do worship God, and God wins. And then we've got Chameleon again says he takes over the warden's residence in Rikers Island. Look, if it comes to this, and I've some people have said there's no way he's ever going to go to jail. That's not going to happen. Well, honestly, I'm not so sure. I wouldn't have thought some of the things that have happened in court have in fact happened. But if he does for some reason get ordered to jail, there's going to have to be some special arrangements. All right. Well, we are going to move on to our next topic. And with that, I want you all to please welcome Merchant to Inside the Law. I'm sure you've never heard of Ashleigh, but those of you who may have heard of her, you will know that she is the Aaron Brockovich of the Fani Willis saga fiasco, the person who brought to light the affair that we all know so much more than we ever wanted to know about between Fani Willis and Nathan Wade. Good evening, Ashleigh. How are you?
I'm good. How are you all? Thanks for having me.
Oh, listen, thank you for making the time. I know that Ashleigh was at a family event with something for her daughter earlier. And so thank you for making the time to come in and talk with us. We were just going over, and we're going to get into your Fani Willis update with the appeal in just a minute. But I wanted to, we've been talking about what's going on in the Trump case in Manhattan. And we were talking about this in the context of the Sixth Amendment and the right to be put on notice if you're the defendant of what you're accused of. And so what Alvin Bragg has done is he said he committed this misdemeanor. And even though the statute of limitations ran, it's really a felony because he committed that misdemeanor with intent to commit another crime. And he literally says in the indictment, Ashleigh, committed another crime, and he doesn't specify what that other crime is. And he does that 36 times for 36 felonies. So I'm just curious to know your thoughts on whether something like that is the kind of thing that ought to be appealed pre-trial, and how do you defend against a charge when the DA makes an indictment that is so vague and says you had the intent to commit some other crime, but doesn't tell you what that other crime was? How do you defend against that?
Well, Phil, that actually sounds a lot like what we have going on here in Georgia, where we have these indictments for making false statements, but the prosecution is refusing to tell us what the false statements are. It's like, oh, they violated an oath, but we're refusing to tell you what oath was violated. They made false statements, but we're refusing to say how they're false or any of that stuff. It's very similar to what's going on here in Georgia. But what I'll say is that the only way to challenge these is pretrial. And if a judge is not willing to do something pretrial, then we end up having to go in front of a jury. And I think that's what you're seeing in New York right now, where Trump is having to go in front of a jury because the judge wouldn't get rid of these. But what's important with this notice, and I'm getting caught up, so I'm not sure, you may have already talked about this, but notice, we need to know what to defend against, first of all. But second of all, it's important for double jeopardy. If you don't put what the person actually did in the indictment, and then a couple years down the road, someone else wants to go and re-indict a case or bring something up, how do you know if they were already on trial for it if you don't put enough information in the indictment? That's the whole point of double jeopardy. So that's really a big problem. But there's so many problems, but that's what we're seeing with all these cases.
Well, and so you raise a very good point, and I want to add back to I want to come back to this indictment because I can add this to the stage. I want to make it big again so that and I won't keep this up here for long, but you can see here where it says, and he goes through, this is count 3 and count 4 and count 5. And it goes on and on all the way through. Okay. And every single one of them says essentially that the defendant in New York committed this crime with intent to defraud and with intent to commit another crime. And then it goes on and said, made false entry in the business records. And they never specify another crime. And so to your point about double jeopardy, what you're saying, and I agree with you, is that let's just say you get found not guilty on all of these. They could draft another identical indictment,
right,
and say, oh, we're talking about something else this time.
Right. Yeah, and that's the problem. These documents are what dictate double jeopardy. They dictate statute of limitations. If you don't know what the prosecution's talking about, then how do you have enough information? And you got to think about it. I mean, we have all these rules for discovery. Discoveries where you get police reports and you get witness interviews and all this stuff, but that's not a constitutional right. The only thing you're constitutionally entitled to is notice of the charges. So you need to have enough information for the Constitution to be satisfied. You've got to have specific notice. You got to know what it is that they're saying you did. And these indictments don't do that. And so they're impossible to defend against when you don't know exactly what the state's saying. But they do that because they don't know a lot of times, and I think that's the case, what we're seeing in the Georgia case. They don't know exactly how they intended to defraud or what the false statement was. And so they're just leaving it really broad so they can sort of throw everything up and hope that there's a conviction based on someone just being, what the jury thinks is a bad person.
All right. So if this is your case, okay, and I know that you've never, ever had to defend a high profile client, but assume that you have. Assume that you have. All right. And let's just say there's a lot of media, and you've never had a case with any media attention, but assume that you have. How do you protect against the stealth juror who's trying to get on your jury and who's got some nefarious plans once he or she gets on the jury? How do you go about trying to protect your client from a stealth juror sneaking in there?
Jury selection is the entire case. I mean, literally, it is the most important thing that we do. And we just try to get these people to talk. And so, judges try to cut us off at the knees and not let us talk and not let us ask these questions. But, I just try to engage them. I try to find out what they like to do in their spare time, try to just see how they react. And one of the things that I think is really important when you're picking a jury is to have other people watching. So a lot of times I'll have my paralegal, I'll have my law partner, or I'll have, whoever, my client sometimes watching jurors, watching their reaction, to see how they interact with me versus how they interact with the state. And you can see, I mean, if someone wants to be there, you usually can tell. There's the two extremes that we see a lot in jury selection. We see the people who don't want to be there and the people who are literally coming up with every excuse known to man to get off. And then the people that are answering everything really favorably and, saying that of course they can be fair, even if you've got something in their history that says that they were victimized and they were the same exact, type of crime that you're on trial for, but yet they're there and they're saying, oh, of course I can put aside the fact that I was actually a victim of forgery. Of course I can be, fair in a forgery case. Those are the people that are really those ticking time bombs that you've got to get rid of because they just want to be on the jury and they just want to ultimately, write a book, go on a podcast, whatever it is. They're not there for justice. They're there for their own notoriety. And usually you can kind of pick them out.
Let me ask you about this. We talked about this a few minutes ago, but not everyone has been here the whole time. And I wanted to see if you can see that. This is from Twitter. The End Wokeness account says that Judge Merchant rules that a juror who joined a Biden election victory parade is not disqualified off the jury against Trump. So, you and the point that I've made, and you and I have known each other a long time, and I know we've both tried cases in some of the same jurisdictions, and you may have had a completely different experience than me, but one of the questions that I always like to ask about is like, did you support the DA? Did you vote for the DA? Even when I was an assistant DA, I'd ask the same question because, we just want to, and then the same thing for the judge, right? Are you a political supporter of the judge? Because these things go to bias. And I am of the opinion that when the defendant is a former president and the current probable nominee of the Republican Party for president, and this, by the way, is about conduct committed umpteen years ago when he was, early on in his term as president, I think they ought to be able to ask who you voted for. But at a minimum, do you think that participating in this guy's political opponents, political nemesis, you might say, participating in his victory parade, do you think that's a challenge for cause, meaning for bias?
I mean, I would definitely make the challenge for cause. And you probably talked about this before, the difference between a challenge for cause and then striking someone with one of your what's called preemptory challenges. We want to get as many challenges for cause as we can because those don't count against our numbers. So here in Georgia, we get 9 preemptory strikes, which means we get to cut 9 people for basically any reason as long as it's not discriminatory. You don't want to have to save that strike for someone who marched in a Biden parade. You want to be able to get those folks off. So what I always do is I try to get them talking, try to get, why did you feel compelled to march in a Biden parade? Because if you think about it, most citizens aren't marching. They're just not. You see on the news marches, but your neighbors aren't out there marching. Most people aren't marching. So if you were compelled enough to spend your free time marching for something, then you really, you want to get to the bottom of that. You want to know why. But one thing you mentioned, or you asked, I wanted to follow up on.
Yeah.
I guarantee every single lawyer in that room knows who these potential jurors voted for. They're pulling those records. And people have those records. They know when they voted. They know if they pulled a primary, a ballot, a Republican ballot, a Democrat ballot in the primary. All that data is online. They're getting all that. So they already know all of that stuff.
Well, it's all about, the Sixth Amendment. We started the show talking about the Sixth Amendment. There's a lot of rights, as you know, in there. Mm-hmm. And the one that is relevant to this discussion is the right to, a couple of things, a fair and unbiased jury. But of course, the other one is the right to be put on notice of what you're charged with. And I think by extension, I don't know that this is a Sixth Amendment or maybe it's Fifth Amendment, but I know you've also got a right to a fair and impartial trial judge. And so if history views this case as being presided over by a biased judge who allows a biased jury to be impaneled, then history is not going to judge this fairly. And I think that, and I want to hear what you have to say, but if I were defending this case, my goal would be to, Trump won this borough by 12%. I think he didn't win the borough, but he won 12% of the votes in that borough in the last election.
Right.
And if you can get 12% of the jury, one or two people that may be a Trump supporter or at least be fair and open-minded, I would focus on those one or two or three people, and I would try my case to them, basically hoping for a hung jury or a mistrial. And I would make sure that I told them in closing arguments, hold on to your convictions. Don't let anybody pull you off those back there in the jury room. And I would pray for a mistrial, because I don't see any way in this particular jurisdiction you're going to get a unanimous jury to acquit Donald Trump.
Oh, yeah. And that's a really good thing to point out, Phil, that, as defense lawyers, we're not always trying to convince 12 people to go our way. Sometimes we're just trying to convince that one or two, and we're trying to convince them and make sure that they're strong enough to stand by that conviction. And so sometimes people wonder a lot, why we're asking certain questions. One of the questions you'll see is what type of job you have. And if you're a supervisor, if you supervise people, if you have hiring and firing type power. And the reason we're doing that is, do you have the guts when you're in that jury room to stand up for what you believe in? Or are you going to be a pushover? And so, it's one of those things where you want those people who are willing to stand up for what they believe. And if they don't think that the state proved it, you want them to hold strong to that and be willing to stand up for that when they're in the jury room. And so that's one of the reasons we ask those questions. But you're definitely playing to those folks who are the holdouts. And, that's the great thing about our country. The state has to convince 12 people unanimously of guilt. But we only have to really convince one person that someone's not guilty, and there's no conviction. I mean, the case goes on, case isn't over, but there's still no conviction. So a hung jury or a jury that can't make a decision, that is still a not guilty, because you are still not guilty under the eyes of the law. So a lot of times we're playing to that 12%, that percent that just says, I'm not just going to roll over and believe whatever the state says. I'm going to stand up for my beliefs. I'm going to have the fortitude to stick it out in the jury room and to keep voting not guilty. And that's reasonable doubt.
And it might also be possible that you could have somebody who's, let's say, that doesn't like Donald Trump, maybe even a Biden voter or a Hillary voter back in those days. You might get one or two of those people who is nevertheless, fair-minded enough to understand that when you make the argument to them that, look, ladies and gentlemen of the jury, this indictment, I wish I could tell you, that he didn't do it, but they didn't tell us what it was he was supposed to have done, right? And so you make the argument to the jury that the indictment doesn't tell you what you're supposed to have done wrong, because it doesn't specify what other crime it is. And even if you have somebody who's maybe a fair-minded enough, but nevertheless, say a Biden supporter or Biden voter, maybe that person will at least care enough about the system to understand that you can't convict somebody when they're not on notice of what they're charged with.
Oh yeah, and when the state hasn't proven all of the charges, when they haven't proven that it's actually a crime, and you're hoping for those jurors who, whether or not they believe that, whether or not they like Donald Trump, that's not that's you don't need to like our clients. Like, that's not part of it. It's not this is not most popular contest. It's whether or not the state proved the charges and whether or not they proved it with evidence that actually, and a process that actually complies with the Constitution. So, even if it's a Biden voter or it's, whoever, a Hillary voter, whoever, a third party voter, as long as they're willing to stand by the Constitution and make sure that the government is doing their job, that's all that you want. And so that's what you're looking for when you're asking these jurors. You're looking for, are you willing to abide by the Constitution? Are you willing, even if you don't like it? And that's what's interesting. We always question jurors after trial. And I've had a lot of jurors that said, I didn't like your client. I think he's a creep, or I think he's a jerk. I've had clients who maybe they cheated on their wife and then they're, charged with doing something. But I don't think he did it,
Yeah.
And those are the jurors you want, because I don't care if you like my client or not. If the state doesn't
for
prove
sure,
the charges,
or they'll say, they'll say, I think your client probably did it,
right?
but
Yep,
but they really just didn't completely prove it. Your argument about what proof beyond a reasonable doubt with is what got me through the jury part of the process in the deliberation room. And so, there are people that can really hate a defendant for lots of reasons. And I think that's an excellent point that not many people are making, by the way, but it's a valid point. And so maybe it's not entirely hopeless. So maybe you can get one or two people that, were not the rabid, sort of, I guess, anti-Trump, never Trump. I hate this man so much I would throw him from the top of the Empire State Building kind of voters. Maybe you can get at least, a couple of those, and you can get some people that are the ones that you just described that can separate in their mind their disdain for a defendant, but also maybe at least some modicum of respect for the process, and can follow the judge's instructions when it comes to proof beyond a reasonable doubt.
Yeah, definitely. And make sure that the government has not violated the rights in the process. That's important. That's the ultimate check. We have all these other checks and balances on the system, but the jury is the ultimate check. I mean, they are literally where the Constitution dies or lives on. They're the ones that decide that. And, you see stuff like First Amendment, you see First Amendment issues. That's an issue that we have in the Georgia case, whether or not the First Amendment should have been, a bar to prosecution, should have gotten rid of the prosecution, something like that. And I've always said this, and I think this really applies in the New York case. If the government doesn't know what happened, it's not the jury's job to fill in the holes. So if you've got an indictment like you've got in New York and they don't know what happened enough to put into the indictment, I don't have search warrant power. I don't have the power to bring in all these, witnesses to testify. The jury doesn't have that power. That's the government. So if the government's not doing it, where is it? The jury doesn't fill in those holes.
Well, those are excellent points. And I want to bring in just to the conversation just briefly, our chat boss, Megan, and she's watching on a delay. So I've got to, gotta mention her name a couple of times before I do this. I want to introduce you, and some of you who haven't met her. Hi, Megan. This is chat boss Megan, who is helping us keep things straight and who has starred some excellent questions. How are you keeping law and order in the chat tonight?
Law and order, we have a really good chat.
Okay.
Everybody here is so wonderful, respectful, and very, very kind. So,
well, you've done a good job of starring. You've brought to our attention some really good questions. And the reason I wanted to get to these while Ashleigh is with us, and we're going to get to her update on the disqualification in just a minute, I promise. But I got a couple of questions while she's here. Sixth Amendment motion on lack of specificity immediately once trial commences, then appellate level, if not granted. So I think what you're basically suggesting, as I interpret it, is that once jeopardy attaches, in other words, once the jury is sworn, the double jeopardy clause takes, effect. And so if you get a judge to toss an indictment after jeopardy has essentially attached, then they can't go back and fix it with a new indictment. That's at least what I think you're asking, and that's my answer. Ashleigh, how do you see that?
Yeah, and that's kind of what I think is the question too. If the trial has commenced, and a lot of people wonder, when does jeopardy attach? Jeopardy attaches when either the jury is sworn, and that means they actually take the oath. So right now, jeopardy hasn't attached in New York. It's not going to attach until the jury's actually sworn in. Or if there's no jury, it's when the first witness is sworn in. So in this case, in New York, it's going to be when the jury is actually sworn. So when you see them take the oath, and a lot of times you see at the end of voir dire, the jury goes home and the judge doesn't swear them. And, as a defense lawyer, I'm always cringing. I'm like, no, swear them, because that is what triggers double jeopardy. So you want that jury sworn. But, if they are sworn, and then let's say the judge then dumps it on this lack of specificity, or an appellate court does later on, they can't go back and retry that at that point. They're done, because that's what we would call like an insufficient evidence type issue. That's not an appeal that goes back and they get to fix it, because jeopardy's already attached. That ship has sailed.
All right. So Michelle's asking, how can the DA upgrade a misdemeanor that's already expired? And by that, Michelle means undoubtedly the statute of limitations. And so my answer is that at least on its face, the statute of limitations for the felony has not expired. So that's why they're charging the felony, because they know if they only charge the misdemeanor, then they know that it's barred. The statute of limitations has expired. So they've got to bootstrap on this felony version, graft it on, and you've got to allege that the misdemeanor was committed for the purpose or during the commission of a felony, essentially, or some other crime, I should say, because that's what this and so all the indictment does is it tracks the language of the statute, but it doesn't specify what that other crime is. Ashleigh, what do you think?
Yeah, and we see that unfortunately a lot when DAs or prosecutors, they miss the statute of limitations on a misdemeanor. They'll go and find a felony, a felony that fits, even if they don't know that they can actually prove the felony. They'll do that because if they charge the felony, even if they lose at trial, let's say they charge the felony and then at trial the person only gets convicted of a misdemeanor. The statute of limitations is satisfied at that point because it's what you're charged with. So sometimes we'll see something that should have been charged as a misdemeanor, but it's charged as a felony so they can get over the statute of limitations. They know they don't have the proof for the felony, but that way they can still get in front of a jury and they can still get that misdemeanor conviction because they've satisfied the statute of limitations. Another thing that happens a lot of times, and we've seen in these cases, is COVID. We had COVID delays. In Georgia, they actually suspended the statute of limitations. So for, months, we didn't even have a statute of limitations in Georgia. So anything that happens during that time period is removed. So it actually extended the statute of limitations on a lot of cases.
Yeah, they did that in New York by, I think, at least 1 year.
Yep.
So the misdemeanor would have maybe expired around, February 2020-ish would be my best guess. All right. Well, thank you for bringing those questions to us, Megan. And thanks for all the hard work in the chat and keeping everybody straight. I'll let you get back to it.
Fannie tonight?
Pardon me?
Are we going to talk about Fannie tonight?
Yeah, we're about to get into our Fani Willis update. And so I'm going to let you go back and wrangle everybody in the chat room while we set that up. And by the way, we've got 1,700 people in here. Go ahead and hit that like button. It will really help. And if you like this content, please feel free to check out the links that are provided in the description to the tonight's show and in the video, because those are the types of things that will help me continue to grow this channel and continue to bring better and fresh and new content, basically to help people understand the real criminal justice system, not just the one you think we have from watching TV, because this is the system that Ashleigh and I live and work in, and we're up to our eyeballs in it. But we know that you folks probably don't have that perspective. And so we try to share it with you, the good, the bad, and even the really ugly sometimes. All right. So let's get into briefly the Fani Willis situation. Of course, everybody here, I imagine, or at least most people understand that what's going on is you have, you've had your motion, you've had your long, multi-part, multi-day hearing on the issue of whether Fani Willis and her office need to be disqualified or should be disqualified for a conflict of interest and also for forensic misconduct, which is the talking sort of in the public, casting aspersions on not only your client, but on you. I mean, Willis came in
Oh, yeah.
there and she came and took the stand like a wildcat with her tail on fire and wanted to call you a liar. It was like the first thing out of her mouth. And so the judge, and I want to hear you say it, but my summary is that the judge gave us all of the ingredients for the disqualification cake, but the judge just never finished baking that cake. In other words, he wrote an order that essentially agreed with most of the things that you were raising, but just disagreed and with what the remedy was. He didn't go as far as what you want.
Right.
And so you can take it from there. What is the situation with that? What has happened, and what do you think is going to happen next? And anything else you want to add, by the way?
Yeah, I think the judge agreed with us. I just don't think he was willing to go as far as we wanted him to and actually make that ruling. I think that he gave the language and he sort of tipped Fonnie off that maybe you should disqualify. And I almost think he was hoping that she would, which was ironic because I said, clearly you don't know what you're talking about, but I would hope that she would actually disqualify herself. And we've just recently, last week, Burt Jones, he had been, so for those who don't know, he was being investigated by Fonnie Willis during the special purpose grand jury. She had worked on on the campaign of his opponent. So she had hosted a fundraiser for his opponent, and that was brought up to the judge. And the judge said, that's not okay. That's not kosher. You got to go. So he was sectioned off. So we've seen that case just sort of sitting for a while. And they just appointed last week a prosecutor to investigate that case. And it's actually the head of our unit. It's called the Prosecuting Attorneys Council, PAC. So they're the ones that decide who's going to investigate that case. And what they did was they appointed the head of PAC. He said, I'm just going to keep it. I'm going to investigate it. So it's going to be really interesting to see what someone who is not as political as Miss Willis, someone who is a much more, considered in the legal community, much more neutral, what he's going to do when he actually looks at that. And if he's going to charge Burt Jones, I don't think that he is. I don't, and that's one of the reasons I brought the motion. I never thought if we had someone who was not politically interested that we would ever see them bring these charges.
By the way, she's referring to the Pete Scandalakis, who's he's the head of the Prosecuting Attorneys Council of Georgia. That's the independent state agency that's delegated now by law. They just changed a couple of years ago. It used to be the Attorney General. I did a show on this, a brief show a few days ago. If you want to go back and try to check that out, we talked a little bit more at length about this. But Pete has, in my opinion, he's fair. He's fair-minded. He took a long time to decide to appoint himself. And my theory behind that is he couldn't find anybody else to appoint it. Nobody else wanted it.
Right.
So Pete is basically taking it upon himself, and there's nothing wrong with that. By the way, my dog Winston says hi, in case you can't hear him. All right, so Pete has taken it upon himself to appoint himself as the prosecutor who's going to determine if there's going to be another person to be thrown in with all these other defendants. But I wanted to sort of flesh that out. I didn't mean to cut you off. Please continue.
Oh, no. I'm glad you did, because there's a lot more to flesh out. So I'm glad that you had some more information about that, because it is kind of it's an interesting topic that we could talk about for a long time, who's appointed and who can be appointed on it. But, so that's a development that we're going to get to watch. We're still sort of watching the clock to see when the appellate court is going to decide whether or not the Court of Appeals is going to decide if they hear this or not. But what I think is really interesting is every time Judge McAfee issues a ruling, a pretrial ruling, he has the ability to say whether or not we're allowed to appeal it. And he's issued some other rulings that he has not allowed us to appeal. And so just this week, the First Amendment ruling that he issued 2 weeks ago, that time expired. And he did not give us. We asked for it. We all asked for it. We all filed the motions asking to appeal it. He didn't give us that. So he thought that this conflict issue was so important that he gave us the right to appeal. But he didn't give it on anything else, even the First Amendment, which is a really big issue. So, to me, that's very telling. That says that he thought this was a really big issue, and he thought he could be wrong on it. He
gave a certificate to Chris Kacheroff, who was in here and did a show with us a week or so ago, and folks can find that and go back and look at it as well. But Chris Kacheroff represents Harrison Floyd, and he gave a certificate of immediate review on the question of whether or not Willis had jurisdiction because to even bring this case, because it had not been referred to her by the state election board. Or I'm sure that I've mangled that, but that's essentially what the issue was. He gave him a certificate of immediate review on that, And I think they filed that a week or two after you filed the one on disqualification. So the clock's ticking on that one as well.
So, whenever you mention things, it like dings in my head. I'm like, oh, wait, I need to talk about that. So that's really a good point, because, and a lot of folks haven't really looked at that. Most cases that go in front of a grand jury are brought by somebody. Somebody refers it to them. And so Chris's argument is, wait, this wasn't referred to you. Like, prosecutors aren't going out looking for things to investigate.
Well,
they got enough.
They do.
Like in Fulton County, like there's enough crime. So they don't need to be going out and investigating. But what I think is really important in this case is that nobody brought this to Fani Willis. She went out and investigated this all on her own. This is something that her office, there was no police officer. There was no victim that called and said, hey, I've got this crime. There was no police that said we investigated it, no GBI, no elections officials, no state authorities, nothing like that. Nothing. She went out and investigated that herself. And so that's, the heart of what he's arguing, that motion that he's arguing, is that, you essentially created this. Nobody brought it to you. Nobody was complaining that a crime happened. So, I just wanted to point that out when you talked about Chris's motion. But, back to the case update. So we're on a clock now to see if the Court of Appeals is going to accept it. We're very hopeful that they will. I think they will. But in the meantime, we're still gathering information. And so what is always interesting when you bring things like this to court is people start talking and records are still coming in. So we're still, subpoenas we issued for February hearings, bank records, things like that, we're still getting more travel receipts. We're still getting all of these things. And so, these are things that if the appellate court doesn't give us what we're asking for, we may be able to rebring a motion. This forensic misconduct is unfortunately not stopping.
And it's ongoing. And we've talked about that on here too. Again, that's another video for folks to go back and check out. We've talked about Willis, and she just won't stop. She's going back out and she's claiming that the train is coming, and she's continuing to talk about, she says the judge has warned her that she's going to keep talking about race anyway. When you're in a hole, the first rule is to stop digging, but she won't. She can't. It's almost like she has this compulsion just to not be able to stop talking about this.
Right. And we moved on from racism. She continued to make that claim, but now we've moved on to feminism. So now she's out parading and, she's campaigning, but now she's talking about how she is the face of feminism. And, as a female attorney, it's just really, don't have a whole lot to say about that, but it's, that this is not the face of feminism.
All right. So let's say the Court of Appeals, back to all right. So the Court of Appeals is on the clock. Do you have any sense of how many more days they have? Because I've heard it described different ways. It's like 45 days from the entry of the judge's order, but they had to wait on the state to file a response for so many days. Okay. If it's a 45-day clock, do you know how many days they have left, more or less?
I would say, so I don't know the exact amount, and I should actually have that on a calendar, countdown or something. Maybe I'll start that on my phone. But, I'd say 25-ish, something like that. It's from when it was docketed. And so we've seen, we've had actually a couple amicus. So we had two amicus filed. We had one filed on our behalf and then one filed against us by the ethics prosecutors, which I don't know if you talked all about that yet.
Yeah, I did a stream on Jay Sekulow and the, and his with the ACLJ, ACLJ. We did an entire one where I went through and we looked at that almost, and that was, by the way, I thought a really, really well written.
Oh,
and they
amazing.
Used authorities, like they cited back to cases from centuries ago. They cited, law reviews. They cited cases from other states, even like Washington State. They really did their homework quite literally, and I think put together a really, really good amicus brief. And that for everybody who doesn't understand, that means a friend of the court brief. It's when you're a non-party, you can basically you can inject yourself into the appeal, if you will, by filing this brief on behalf of whatever your organization is that takes a certain position in support of or against another position. And so there was amicus briefs these are called friends of the court, that were filed. And Ashleigh was saying that one was filed in support of Willis and another really good one was filed in support of the defendants.
Yeah, let's talk a little bit about the one that was filed in support of Willis, because you and I talked about this for a few minutes this weekend, Phil, and we never really got a chance to dig deep into it. But I know you've read about it, I've read about it, so I think your viewers might be interested in it.
Yeah, go ahead. What do you got?
So the person who authored the amicus brief in support of Fani Willis, so she's a defense lawyer down in the Savannah area, and she's the local counsel, the one that filed it and did all that stuff. But she has a history of bringing up cases where she was trying to get people out of prison who had, and it's kind of it's a longer story, so give me a minute to sort of walk through it. So what happened was, in the federal system, there were this cop, this federal agent who was having sex with the prosecutor. So the prosecutor is married, agent is married. Prosecutor calls agent to the stand in all of these trials. Couple, like 3, 4, 5.
No bias there at all.
Right. But it gets worse. Not only did the prosecutor call this person to the stand, but the prosecutor also argued during the trial, hey, this guy is great. You should believe whatever he says, yada, yada, yada. So they didn't disclose this relationship to anybody. So this lawyer, who is now saying whatever Fani Willis did is fine, she found this out, and she's actually brought all of these charges against them for having this illicit affair, saying that all these convictions should be reversed because of the illicit affair. All of these convictions should be reversed because the prosecutor was in court vouching for the credibility of the special agent, just like Fani Willis was in court vouching for Nathan Wade this whole time. I mean,
well, that's some irony there. I mean, what would be the reason that she would be behind the filing of the amicus brief in support of Fani Willis? This seems to be very, very strange.
It totally does, because she's literally gotten people out of prison on almost the same facts. Like, it's crazy. And, you think she thought it was unethical. She authored all these briefs and did, news articles and all this stuff saying that it's unethical that this prosecutor was sleeping with the cop, but yet she thinks it's completely fine that the prosecutor is sleeping with the prosecutor. Like, it doesn't make any sense. Like, that's the person that is saying all of these, ethical dilemmas. Like, this is fine. Look the other way. What Fani and Nathan are doing is fine. Did you update your viewers on Nathan's latest divorce filings? I wasn't sure. We've talked about, not tonight. We haven't talked about it tonight, but hey, this is while we're here, everybody's interested. What's going on in Nathan's divorce? We know that his wife is asked to maybe hold him in contempt. And I did a live stream, and I went through that, and I talked about, a contempt doesn't mean that you're necessarily trying to throw somebody in jail, but it could happen. It really could. Yeah. Well, and it gets even worse than that. So there's been some pleadings that Mr. Wade filed saying that because he lost his special prosecutor job, which is interesting because when he testified, he said, hey, I'm not really making all that much money. I actually made way more money in private practice. So he's here now saying, because I lost my prosecutor job, I can no longer pay my kids' rent. I can no longer pay my tuition for my children. His college-age children, saying I can no longer pay for them.
Well, hold on a second. I don't mean to interrupt you, but Chris Katcheroff was on. This is when I interviewed Chris about his case involving Harrison Floyd. It was the same day that this whole thing broke about the contempt, and in the contempt filing, it said basically that alleged that Nathan Wade, as soon as they entered into what's called the temporary order, which governed the financial responsibilities of the parties during the pendency of the divorce litigation, Nathan allegedly cut off his kids, stopped paying rent for a daughter, and stopped supporting another child that was over in Europe at the time, and said, if you want more money, get it from your mother. And I'm summarizing, but essentially that's it. But at the time that he allegedly said that, oh, and by the way, the reason his wife wants to enforce the agreements because she's saying he's not paying his share of the medical bills that she needs him to pay because she's got some health problems that apparently are pretty significant. And so at the time he allegedly cut off his children and said, go get the money from your mom if you want more money, he still was a special prosecutor.
Oh, yeah. Oh, and he was billing for sitting in court for all these hearings, and but he can't pay his kids' rent. He can't pay tuition, can't pay the things that he is specifically ordered to pay. And some of that money we saw all the trips that he took, not even the trips that he took with Miss Willis, but the trips that he took with other folks, with friends of his, and now he can't pay for his kids. I mean, it's insane, but we have a trial date in that. Judge has set a trial for July. So the divorce will actually go to trial, which is going to be really interesting to watch. I'm hoping that'll be live streamed or we'll be in court, seeing what's happening, because he's going to have to testify about that.
Well, you don't think that'll settle? Because I know that most cases statistically will settle, and sometimes on the eve of trial, these people don't want. And maybe it's too late. Maybe the horse is already out of the barn, but
Right.
Sometimes they don't want their dirty laundry, aired on a public stage like this.
Yeah, but if what he's saying in his pleadings are true, which obviously we can't take that for face value, but if what he's saying is true, he doesn't have any money. So if he doesn't have any money, he can't settle it. So it'll be interesting to see, because he's saying he's broke, and if he's truly broke, then he's got no money to settle it. So,
well, she paid him almost $1 million. Well, 700 and some change by last count. You might know better than me. But of course, that was supposedly, a part-time job. He
Right.
had a law practice that was viable, at least. Is that essentially what he's saying? Is he saying that I threw all my time and effort into this case?
Yeah.
And now I'm off the case and my law practice has suffered? Is that what he's saying?
That's exactly what he's saying. He's saying, I didn't have time to nurture my law practice, which, it's interesting, because if you look back
Time to nurture
early,
something else.
if you look back early in this case, they filed, he and his law partner actually sent out these advertising flyers to all of our clients. So they're still advertising,
Yeah.
I mean, they sent them to all these Fulton County clients. He was advertising he was a special prosecutor. So I'm not really sure that that's what caused his business to decline. I'm thinking it might have been all the stuff he testified to on the stand. Perhaps that's what caused his business to decline. Plus, he lost his job with Fulton County. I mean, a job where he's making, he essentially is a government employee, but he's making 5 times the government salary.
Well, the clock's ticking on this appeal. My prediction, look, I should get out of the prediction business, because I predicted we were going to hear something by the end of last week. And of course it's coming on, but I guess we could, you could hear tomorrow that the Court of Appeals is saying yes or no on taking your appeal. Is that right? You could hear it anytime.
We could. Yeah. And we get email notifications. So it's one of those things where you're like checking your email, we could get it anytime. So, and luckily they have not had a cyber attack. So the Court of Appeals will get it instantaneously. We'll get it when it comes down, because we don't have to wait like we do in Fulton County for the cyber attack to work its way through. But what will happen if they do take it is then they'll actually set it up for oral arguments, which are awesome, because the Court of Appeals publishes those, everybody can watch. And the thing about oral arguments that I think are really great is you can get a sense for what the court is looking at. Also, you find out with oral arguments who's assigned to the case. So in Georgia, we have a 3-judge panel system where the Court of Appeals, actually, they'll have 3 judges assigned to decide whether or not they're going to hear this appeal. But those 3 judges change. So the ones that actually do hear it, once it gets past that first process where they decide whether or not they're even going to hear it, 3 new judges decide what we call the merits. So decide whether or not we win or lose.
Oh, all right.
Yep.
So
It's
I didn't well see. So all right, so you've got a 3-judge panel that's going to decide whether to hear the case. But see, look, you can go to their website and it has all the rules of the court, but you can't really find this information.
Nope,
but
it's
apparently 1 judge out of the 3 can agree to take to hear the appeal, but it would take 2 of the 3 judges who hear the oral argument to actually reverse the trial judge.
Exactly. Yes.
By the way, if Fonnie is tossed by the Court of Appeals, can Fonnie appeal that?
She could appeal it to the Supreme Court, but it's what we call by permission. So it's not automatic. So she would have to have permission to do that, to appeal it further to the Supreme Court.
And if you lose, let's just say the Court of Appeal says we're not going to hear it. Can you then ask the Supreme Court to order the Court of Appeals to take the case?
Yes. Well, we actually can ask the Supreme Court to hear the case. So if we lose, and that's what we do. If we lose at the Court of Appeals, we'll move up and say, Supreme Court, We want you to hear it. And what's nice about that is the Court of Appeals, it's only 3 judges. When you get to the Supreme Court, you've got 8 judges. So you've got a lot more judges that are going to, determine whether or not they hear it. But the reason that oral argument's so fun is you find out which judges are assigned to the case. So, in the Court of Appeals, you can garner a lot of information from who shows up at oral arguments and what type of questions they're asking. Are they asking questions that are putting us on the hot spot? Or are they asking questions that's putting the state on the hot spot? And they will ask very direct, pointed questions in oral arguments that can really give you a sense of what's going to happen. But the other thing that I think is interesting is if they do accept it, it's going to be probably 6 months before we have a ruling. So we're, looking at election season. I mean, we're going to roll right on through the fall before we actually have a ruling. We would be
there's no way
Yeah.
this case is going to be tried or anything before the election. The question from an anonymous chatter says permission from whom? I think what she was talking about actually was saying that in order for Willis to, let's say Willis gets tossed by the Court of Appeals, she could ask the Supreme Court to untoss her.
Yep.
And that's a discretionary appeal. It's called on a writ of certiorari. And so the Supreme Court would not have to take up her appeal. That's what that was about.
Yeah. And I see a lot of people in the chat asking what's going on with the Senate committee.
Yeah.
So in Georgia, we don't have a full-time Senate. So I think that's important kind of as a backdrop. They're only part-time. So their session is over. They didn't have a whole lot of time to do it, but it doesn't mean it's over, that this issue's over. So my understanding is they started doing the investigation, and part of what they're investigating is if there needs to be amendments to laws, and they're still doing that. So what would happen in what we could sort of call the off season, they're out of session right now, is they're going to continue to talk about that. And that's one of the things that they asked me, what laws should we look at? And they're going to look at those. And then I think we will see some legislation proposed in the state of Georgia. I think we might see some legislation that fine tunes the ability for prosecutors to have this, use these funds, no oversight. I mean, one of the things that we did see was we saw this prosecutor oversight committee that Governor Kemp has finally signed into law. And so we've got that committee. They're going to be the oversight. There was no oversight before except for the state bar, and that's not really any oversight. The state bar really only cares if you are stealing people's money. I mean, they care about some things, but the state bar is a whole different process in Georgia. So the only oversight was this committee that Governor Kemp wanted, but it took a while to get passed. The first one was shot down. They had to rebuild it. It did pass. Governor Kemp signed it into law. So coming July, we will have a prosecutor oversight committee. I think the Senate's going to probably watch that and see what happens. But I do think we could see some new laws or some amendments to the laws, particularly how money is spent. But, not just the Senate. I've been watching. So I watch the Fulton County Board of County Commissioners meetings. They have them once a month, and they have tightened the purse strings. They had a major audit. They didn't call it an audit, but it was an audit done. And they found a lot of margin for misuse in the DA's office. And so they're tightening the purse strings. They've actually had to let a lot of people go in Fulton County at the DA's office because they have tightened the purse strings on her spending after seeing all of this. So, I think we'll see a lot of other changes, whether it comes out of the Senate or not.
Yeah, Rachel Kaufman and I had a discussion the other day about this, and we actually had some video from some of the Fulton County shenanigans, and it's really quite striking. They were coming down pretty hard on the sheriff's office as well as the DA's office, saying that basically their spending was like at high risk, so to speak, risk, I guess, for being wasteful or perhaps even fraudulent. And so it was very, very interesting to see that, the world is kind of shocked to see, okay, what's going on with the Fani Willis and all the things that you exposed. But really, that's a symptom of a much bigger rottenness, if you will, that sort of has infected the county, and it starts at the top. The county the commission is almost just dysfunctional because they're yelling at each other, they're screaming, they're acting like 2-year-olds. But at the same time,
I had to turn it off, and I like to listen to that stuff, but literally it was like having little kids that were bickering, and it was insane. I was just like, I can't even deal with this anymore. Listening to it, I was shocked at, I see a question. So we have seen Anna, but she's never on any of the pleadings. She hasn't been active in any emails. So, she's there, but not really, doing a whole lot of stuff. So we'll see. We'll see who's, my understanding is Miss Willis is going to try the case if it ever gets tried, but, who knows?
Well, there was, somebody had said that Cross was present in the courtroom at the last, I guess, hearing, but maybe was sitting in the gallery or something, but who knows at this point. Willis the county commission may cut her off. If they still have to pass a budget for next year, they may cut her off, and she may not have the ability, unless she takes it illegally or otherwise from some other pot of money somewhere, maybe from the cash under her mattress, to pay these special prosecutors.
It's a good question. I don't know what's going to happen with those purse strings, but I think they're definitely being tightened. I mean, you saw that with the Board of County Commissioners. The spending is a lot, and when you've got people dying in the Fulton County Jail, that's insane. You cannot operate a third world country jail, and our jail in Fulton County is worse than the third world country. You can't do that and then be spending money on boyfriends and 3 special prosecutors for a non-violent crime. I mean, the taxpayers are not going to be okay with that. And they've got to have some oversight. It's crazy.
All right. Well, we're going to have to leave it there. Thank you for taking the time out of your evening. I know that you had other things to do. So thanks so much for coming in, and I've kept you much longer than I thought we were going to, but obviously we always want to hear what's the latest, and we really appreciate you coming in and explaining all that to us. And as you've seen, we've got almost 2,000 people in here. You obviously are much more popular than me. When people saw the word got out that you were coming in, the chat room, it just exploded.
I'm honored.
Thanks.
Well, thank you for having me. I love the questions. I like talking about law. I'm kind of a dork like that. So
yeah, well, and anyway, and you're a great friend, and thank you for doing this. And I will let you get back to your family. And with that, everyone, listen, I wanted to just take a minute and thank you, JD. I appreciate it. Thanks to all of the people that are here, that have been participating in the chat. I always like to go back and look at these comments, and I try to respond to them. But these are the places, look, whether it's in the live chat or later, comment on the video, because we like to hear what you're interested in. This is, I really want to bring you the show that you want, because if we're talking about being inside the law and bringing you the real justice system, there's a lot there. I mean, and I just want to make sure that the things that we're talking about and the things that we're doing aren't too repetitive, and also but at the same time, I want to make sure they're topical and timely and consistent with what's going on in the news, because we really do want to bring you the real criminal justice system. And take a minute to hit that like button. I really appreciate it. And thank you all very much for the super chats, and for all the support. And if you, like I said, if you like what you're hearing and seeing here, there's some links in the show description that you can take advantage of to show your support, because that helps me continue to bring you all of this, the content, and hopefully keep making improvements to the channel, because it's really growing. I think I'm at almost 25,000 subscriptions. By the way, if you haven't subscribed, go ahead and subscribe, and ask your spouse, ask your parents, ask your kids, ask your neighbors to subscribe, because I'm told that getting over that 25,000 hump is kind of a big deal, but I'm truly honored that we're even this close. So thank you all again very, very much. So today, just remember, it's about fairness. It's about fairness in the justice system. Today, we started out, and the whole point of this was to be mindful that the 6th Amendment to the Constitution requires that the trial be fair, whether it's Donald Trump or your case or your neighbor's case or anybody else's case. Your trial has to be fair. Your judge has to be fair. Your jury has to be unbiased. Those are the constitutional guarantees that we all are blessed with. Our soldiers throughout history have fought and died for those rights, and they're very, very important. And so the minute that the rights are denied to one person, it diminishes the sanctity of the entire system, and the system then becomes unreliable, and it yields results that we can't have faith in, and history will not look kindly upon our republic if we allow the system to fall into such disrepair. So with that, I'll say good night, and we'll see you back here next time inside the Law.